All right, great. Good afternoon, everybody. My name is Vijay Kapoor. I have the honor of serving as receiver for the city of Chester. Today is August 12th of 2025, and this is the Municipal Financial Recovery Advisory Committee meeting, or MFRAC for short. Delighted to be joined here by the Honorable Mayor Stefan Roots from the city of Chester. From Delaware County Council's appointee, we have Ms. Kelly Diaz. And of course, from DCED, we have Mr. Andrew Sheaf. Also delighted to be joined here by my special assistant, Jacob Polikov. Cody Deal, unfortunately, will not be with us today. He is out this week, but he will be rejoining us at our next MFRAC in 2 weeks. In terms of public comment, we do not have any, did not receive any public comment between last time and now. If any did trickle in, and we missed it, we will be certain to get it to the members of the committee today as well.
Mr. Receiver, Mr. Receiver, Mr.
Yes,
Receiver.
sir.
Did you say Councilman was out there?
I did not see
Okay.
Councilman Shaquan Davis on.
I'm sorry.
But he gets on here, I will make sure to let him in. Before what I had today for the committee is an update on the water asset monetization process that I will go into. I'll go into it's a fair amount of detail today, so just forewarned here, but a lot of information that I think is important to the committee as well as to the public. Before we get into that, though, today, is there anything that any of the members assembled here wanted to raise before we get into anything we wanted to announce here on the MFRAC? Just offer it now. We'll also offer it at the end. So in case anything pops into your mind at that point, we'll be happy to do that as well. But anything before we get started here in the presentation? Mayor?
Yeah, just real quick, we just had a meeting with PECO. There's a lot of utility work being done in the downtown area here in the city of Chester. Some of the business owners were concerned about scheduling and, impact on their business. So it was great to convene PECO, who came with everyone from their customer relations to the folks putting the pipes in the ground to answer any questions that were had. So we had 3 business owners come and join the meeting. For those who didn't come and join but still has concerns, please talk to the 3 who showed up, because they walked away with some good information. You can all also reach out to me. But what has to be done next? Main work, putting in new mains in the streets, are complete. But what has to be done now is putting new service lines to all of the buildings that will be served by gas. One of the challenges will be scheduling. The other challenge will be those buildings that aren't in use right now. They'll have to decide whether to put a service line in, and that's only going to happen if a building's going to be open within the next 6 months to a year or so. If not, they'll put a stub there, for future. But we would love to get in touch with all the business owners or property owners to get an idea of what their intentions are, to minimize any further digging after everything's repaved and new sidewalks are put in. So, for those of you out there who are listening, who are part of the business community in the Central Business District that are affected with the new gas mains, please get in touch with this office so we can make sure it's done as smoothly as possible.
Great. Thank you, Mayor. Thank you, Mayor. It's good to see the infrastructure going in the Central Business District. And for anyone who's been downtown, you'll know there's a lot of construction going on. So it's a lot of infrastructure improvement, which is great for the city. Any other updates from any members of the committee before we get into it? All right, let me go ahead and let me get started. Let me go ahead and share my screen here. And folks can let me know. Jacob, can you give me a thumbs up if it's up? Great. All right. Wanted to give everybody an update here on the water asset monetization process, which effectively is the procurement process for the city's water assets. So got a couple different objectives here, and you all will note a new outline here as well. So we're hopeful this is a little bit more interesting than the normal just blue and white that I had before. But top objective here is we want to update residents on the status of the monetization of the city's water assets. We also want to use the opportunity here to clear up any confusion that we continue to hear about monetization versus privatization and what we're actually doing here in the city of Chester. And the third thing that we want to highlight to folks, because I often hear this question from people, which is like, why is this taking so long? And this, not only the monetization process, but also kind of bankruptcy more generally, is I want to talk bluntly here and honestly about how the Chester Water Authority's apparent legal strategy is really infringing on the city's bankruptcy rights as they use the court system to stall the RFP process. And I want to provide some facts behind that statement. So, as many of you all know, and we're going to spend a little bit of time kind of going backwards just to get everybody up to speed and get everybody on the same page. So, back in 2022, then receiver Michael Dowry filed bankruptcy on behalf of the city. In 2024, also then receiver Michael Dowry filed what's called a plan of adjustment with the U.S. Bankruptcy Court that included a plan to monetize the city's water assets. And when we talk about water assets, we talk about the Chester Water Authority, the Stormwater Authority, and the city's reversionary interest in Delcora. And Delcora, as many of you know, is responsible for the sewer service. And as part of that plan of adjustment, what the receiver did was kick off a process that led to a request for proposal, which was seeking qualified bidders for the water assets, for a way to monetize the assets. Now, the reason why we did this and why the receiver did this is in order to emerge from bankruptcy, the city has to meet its fiscal obligations to its creditors, but also it needs to continue to provide vital and necessary services to its residents. And what you see kind of across the country when we talk about financially distressed cities, and this happens with communities that are not only in bankruptcy, but are also sort of teetering on bankruptcy, is they often sell their utilities to companies in the private sector to generate large amounts of revenue. And when you sell your asset, when you sell a public asset to a private company, that is called privatization. And again, we've seen that kind of throughout the country. You see it with parking assets, you see it with water assets, you see it with sewer assets. You see it in a variety of areas. And again, if you take a public asset and you sell it to a private company, that's called privatization. Now, what we're doing in Chester, what the previous receiver, Michael Dowry, did, and what I am continuing, is our plan is to monetize the city's water assets. And that's different. That still allows Chester to get either a lump sum of money or a lump sum plus annual payments. But the important part is, and the very important part is, it keeps these systems in public ownership, and that is answerable to the public. So this could mean selling the water assets to another public utility or entering into an arrangement for an outside company that would manage the assets for a fee, but again, would keep them publicly owned. So this, I think, is a really important slide. And I'll be honest with you, I'm a little bit kicking myself that we didn't put this out, in previous months or when we whole started this process. But I want to show you the difference between privatization and monetization. Again, privatization is selling an entity to a private company, and that's owned and controlled by individuals or shareholders. And oftentimes those are publicly traded. But the big point about in privatization that we'll talk about in a moment is there's a profit motive, right? That's why private companies exist. Now, monetization is different. Now, it has the same benefits monetarily for the city of Chester as privatization, except the big difference here is it keeps the assets publicly owned. So the operator must answer to the public. So sometimes we heard in the past when we talked about this, well, when you say publicly owned, do you mean publicly traded? And the answer is no, we don't mean publicly traded. So a publicly owned is owned or controlled by the government or the public. Again, in a situation like that, we don't face pressure from shareholders to raise rate for investor or shareholder gain. There's not a profit motives, excuse me. Instead, what that option does is it keeps the power with the government and accountable to the government and the people. Now, publicly traded is a private company that has offered shares of its company to be bought by the general public on a stock exchange. And the ownership there is based on who owns the shares. So this is not part of the receiver's plan. So I want to be very clear that publicly owned and publicly traded are two totally different things. And what we are focused on and what we are requiring is that the assets remain publicly owned. And why is public control so important? So why are we requiring this? The first thing is we want to protect ratepayers, and we include rate, and obviously Chester residents are also ratepayers. And so what we've seen is since 2016, the Public Utility Commission, or the PUC, has allowed private water companies to buy at least 21 local water and sewer systems under what's referred to as Act 12. And what you've seen from that is you've seen increases, right? Rate increases, ranging anywhere from almost 45% to almost 117% in those markets. So obviously we're very concerned about that. And there's a reason for that, right? There's a profit motive if private companies buy the asset. You don't have a profit motive when they remain publicly owned. In addition to protecting ratepayers, there's also just the common good. So I believe as receiver that the common good is served best when we have certain essential services that really touch everybody, especially something like water, right, which is necessary to life, as well as sewer and stormwater, again, which all go towards important public health functions, that they remain in public control in order to ensure fair rates and a quality of service for all. So, the question is kind of like, is everybody on the same page here? While I wish it were the case, and again, we're trying to operate on the receiver side and on the city side in good faith, the answer is no, not everybody's on the same page. As many of you know, and maybe some of you who are watching and maybe even commenting at this point on Facebook, is that CWA has repeatedly accused the receiver of trying to pursue a deal to sell the water assets to a private company such as Aqua. Again, regardless of how many times CWA says it or Save CWA, who's the same thing as CWA, says it, this is not true. If we had wanted to sell this to a private company, we would have done that way back in October of 2021, when at that time, the then city council unanimously asked the receiver to allow it to enter into an asset purchase agreement with Aqua back in October of 2021. And again, the only reason why that didn't happen was because the receiver at the time, then Michael Dowry, issued an order not to allow the city to enter into that agreement. Now, that's the one thing, right? You all have heard on that on the one side, right? CWA falsely saying that the receiver wants to privatize the water assets, which we do not. And on the other hand, right, we have the Official Committee of Retired Employees, and they represent all retired city workers in the bankruptcy. And as many of you know, they've sued the receiver in an effort to force the receiver to consider a sale to a private company. All right, and their argument is that it's the interests of its members are best served if the receiver maximizes the value of any sale. And so their position is that the privatization of the asset should also be permitted. So what the committee is asking the receiver to do, and again has filed a lawsuit against me, is to encourage offers from private bidders to acquire the assets, right? To have the city sell the assets to a private company. And the receivers made it clear that while all bidders, both public and private, can participate in the RFP process, the receiver is seeking a transaction that keeps ownership of the water assets in public hands, right? Keeps it publicly owned. Just a note here, again, this is a reality. We'll be talking about legal bills a little bit later, because unfortunately that is it's partially a byproduct of bankruptcy, but it's also a byproduct of certain strategies that organizations may decide to take. But the committee's legal bills are paid for by the city of Chester, which means it's paid for by the residents because they are a special committee approved by the bankruptcy court. So let me just kind of summarize here for a moment. This is a little fiction versus fact. We're going to play this game, I think, a little bit going forward on future MFRACs. The fiction, right, is that the receiver wants to turn over ownership of its water assets to a private company. That's fiction. That's not true. The fact is the receiver is clear that ownership of the water assets must remain in public hands. So hopefully this slide will end any of this debate kind of going forward on it. But this is as black and white as I think we can make it. Now, there is another layer that's happening here as well, and that is the Pennsylvania Supreme Court case. And as many of you kind of remember, for decades, Chester City Council was the entity that was solely responsible for appointing the Chester Water Authority's board. And that meant that Chester maintained control of the water system. But as you all may remember, and we did a two-part MFRAC on this that to me was pretty illuminating and shocking and eye-opening, even for me, having been here in Chester for as long as I have. But in the waning days of the state budget negotiations back in 2012, the Pennsylvania General Assembly quietly changed CWA's governance structure. It changed the Municipal Authorities Act, is really what it did, which changed CWA's governance structure, basically at the 11th hour, with legislation that was really surgically designed to apply only to Chester. It is fascinating here, right? In the language, and we provided to you all earlier, and I encourage folks to go back and look at this, but you have single municipal authorities, you have joint municipal authorities, and then you have this paragraph, and it goes on for about 5 or 6 lines that creates this other type of entity. And it just so happens that it only applies to the Chester Water Authority. It's pretty incredible. But what that did was it resulted in the board governance structure changing to ensure a majority of CWA board appointments come from outside the city. So not only did it take governance control from the city of Chester, right, where it had been for decades, but Chester residents received no compensation for that, right? So any other entity, right, any other authority in the Commonwealth of Pennsylvania is under a different structure. It's only the city of Chester that was treated this way. And again, Chester residents, the city of Chester, received no compensation for that change in the board structure. But what it did was it also left a question, right? Was who owned the water system, right? It changed the governance, but it prompted the question of who owns the water system. So back in 2021, an en banc panel of the Pennsylvania Commonwealth Court, which means all the judges who sat on the court, ruled that the city of Chester has the statutory ability to obtain the assets of CWA. So basically what it meant is, under the Municipal Authorities Act, that the Commonwealth Court ruled that Chester can be considered the owner of CWA. But after an appeal from CWA, the Supreme Court agreed to hear, and not just from CWA, I should also include Chester County. Delaware County didn't join in, but Chester County did. So Chester County and the Chester Water Authority were the two who appealed. The Supreme Court, Pennsylvania Supreme Court, agreed to hear the case, and oral arguments were made in May of this year. So we expect a decision either later this year or early next, and that's going to determine whether and kind of how the city can use the RFP process to monetize the water assets. Because here's the stark reality, and I said this in response to a question that was asked to me by a Chester City Council member, is what happens if the Supreme Court rules against the receiver? And the answer is it's bad. Like what's going to happen is it will put me as the receiver in a very, very difficult situation to make because the city will be in a difficult financial situation. It'll make that situation much worse. And unless we find other revenue streams, it's likely going to result in deep cuts to city services. And the other group out there, and again, this is, I think, part of the reason why they are aggressively trying to pursue the privatization concept, is it would also impact retirees. They would likely see severe cuts to their pension and healthcare benefits. But the point is, if the Supreme Court rules against the receiver, well, really, it's not going to matter whether we want to privatize the system or not, during the RFP process, right? The court will essentially have said that the city doesn't own. It may say that the city doesn't own the asset, right? But the point I want to make here is, if the Supreme Court rules against the receiver, this is going to have a significant impact on the city, on its residents, and on its retirees. And again, this isn't meant to be a threat. It's the reality, right? It's the reality of the situation that the city is in. So the question becomes like, well, why don't we wait for the Supreme Court decision to do the RFP, right? Because if it goes against the city, then the arguments, well, you're wasting all this time and effort. Well, our response to that is actually time is not on Chester's side. The city is facing immense fiscal pressures, so we have got to move quickly if the Supreme Court makes a favorable decision for the city. What we want to do, what I want to do, and I know what the residents want to do, is that Chester get out of bankruptcy as quickly and judiciously as possible, and in a way that the city will have the financial means and stability to provide vital services to residents for decades to come, right? We want to get out of this as quickly as possible, but we also want to solve the problem. And if we delay this, that just means greater cost to taxpayers in the Commonwealth. So what our decision is saying, look, we want to move forward with the RFP. We acknowledge the fact that the Pennsylvania Supreme Court is deciding this case. And if depending upon their decision, the RFP, may not go forward. But we understand that, and all the bidders understand that. But our view is that we need to have this going forward. We need to act in good faith and allow this RFP process to move forward. Because in the event that the Pennsylvania Supreme Court rules in favor of the city, we want to be able to act quickly, right? And again, consistent with the requirement that the assets remain publicly owned. So what's in the RFP, right? So again, I keep repeating this, but it's important that people hear it. Is the water assets must remain publicly owned, and we also required that bidders have successful experience running or managing water systems. That was part of the first part of the RFP process, was qualifying qualified bidders, right? You couldn't just be anybody who submitted a bid, right? These had to be entities that had successful experience running or managing water systems. But beyond that, right, it wasn't just about saying we want to keep these assets publicly owned. What the receiver, and I'm continuing, is explicitly expressing our desire that bidders maintain affordable rates for all, preserve public sector employment opportunities, preserve public access to and the use of the Octorara Reservoir, either through the creation of a land trust or other protective measures, promote cost-effective capital reinvestment, enhance service to customers by improving access to capital, and boosting operational efficiency to improve service delivery. So it wasn't, again, not just saying the requirement that we keep it publicly owned, but there's other aspects that we think, the receiver thinks, i.e. me, thinks that we want to encourage bidders to do. So what's the status of the RFP? Again, I said earlier, the RFP we did the request for qualifications. So we're in the process right now of soliciting bids from the entities that were qualified. But the problem right now, and I'll get into it in a moment, is that process has been delayed. Not from anything on this side, not from anything on the city side or anything from the bidders. But it's been delayed. And now I am pushing back the deadline for responses to the RFP by 60 days. So why did we do that, right? Given the urgency, given what I'm talking about before, given the desire that everybody wants here to move this process along, why did we have to delay? And the answer is CWA's legal strategy. CWA has been engaged in very costly and time-consuming legal proceedings, while it refuses to turn over essential records as ordered by the bankruptcy court. Since December of last year, CWA has made, I think we're up to 18 now, but at least 15 filings in the U.S. bankruptcy court to slow the process. And I'll talk about those in a moment. It got to the point where back in July, the city and the receiver actually filed a motion in bankruptcy court asking that the court enforce its own order and require CWA to turn over records to the receiver to be used in this process. So I want to be clear about what this is all about. This is about information that the city is allowed to get under the bankruptcy process, and that the bankruptcy court has already ruled the city has a right to get. And CWA refusing to turn over these documents, and B, engaging in incredibly costly litigation that is running up legal fees, both for the receiver to have to respond to all of this, as well as to ratepayers who have to pay for all of this. CWA hasn't won anything in the bankruptcy court as it relates to this information. They haven't. But they have churned an incredible amount of litigation over this time that has really delayed the process. And again, this is all about getting information that the bankruptcy court has already ruled that the city is entitled to. And in most bankruptcies, this wouldn't even be an issue. And so, I want to be very, very clear about that. However, CWA wants to categorize this and otherwise, that is the heart of what's going on over here. And the other point that really gets me, frankly, very personally worked up is that this is infringing on the rights of the city in bankruptcy. So an entity that files for bankruptcy has certain rights under the bankruptcy code. All the city is trying to do is to enforce and to utilize its rights under the bankruptcy code in order to get out of bankruptcy. And again, just like we saw with Chester being treated differently back in 2012 with having the board governance structure being taken from it without any compensation, here we are seeing litigation, filings upon filings upon filings by the Chester Water Authority's lawyers that is delaying this process. And so, there have been various interesting reasons the CWA has come up with for refusing to turn over essential records. Most recently, they invoked the Pennsylvania Public Utility Confidential Security Information Disclosure Protection Act, that we'll call the CSI Act. And that law safeguards certain information of public utilities from public disclosure, particularly when that information could compromise the utility's security against potential sabotage or criminal or terrorist acts, right? But actually, the court had earlier rejected CWA's arguments that it could refuse to produce the documents on the basis of the CSI Act because, among other things, the city is not publicly disclosing the records. So the CSI Act has an absolutely important purpose, and the city and the receiver are going to comply with that law, and we're going to comply with it to begin with. But what CWA is doing is misreading the law and essentially using it as a shield not to provide information to the receiver. So it was interesting because, again, CWA told the court, the bankruptcy court, that it was producing the requested documents when, in fact, it stopped producing them on February 27th of 2025. As part of this process, even though CWA was blaming the city and saying the city didn't have any policies regarding CSI, the CWA actually admitted in a deposition that it has no written policies. It has no written policies or protocols regarding the CSI Act. So CWA was claiming that the city had to live up to these certain standards regarding electronically hosting confidential security information, but it actually didn't have the protocols, the required protocols itself. And it doesn't know whether its own lawyers are actually living up to the standards and the requirements under the CSI Act. The CWA also claimed, so as part of this process, what we are trying to do is also to get an inventory of the assets of CWA. That is typically done in any type of water asset monetization, right? Because if any entity is putting up significant money in order to either acquire or to manage an asset, it needs to know the quality and what the assets are. So this was very interesting, right? So CWA claimed that it doesn't allow and so as part of that, the city was looking to have a third party come in and inventory this, right? Go onto CWA's property and inventory this. But in refusing to do so, CWA came up with this argument and claimed that it does not allow the public into secure and confidential areas of its facilities. But as many of you may have known, CWA actually gave Chester City Council members a tour of its facilities, and it made Facebook posts that included pictures of the sensitive areas of the water plant. And in fact, CWA permitted a Chester City Council member to actually live stream on Facebook from these supposedly secured facilities. Now, we didn't put the picture in, but I kind of wanted to. There is this incredible photo of the tour of the Chester City Council members in probably one of the most secure places. And you've got the executive director of CWA, you've got the board chair of CWA, and you've got a Chester City Council member who is live streaming it. And this was all photographed. And not only was this photographed by Save CWA, but it was actually posted to the Save CWA website. So in an incredible, indication and evidence that karma does indeed exist, that photo was taken, and we made that as part of one of our filings. But it just goes to show this argument that CWA had been making, that it doesn't allow the public into secure and confidential areas. I mean, it allowed a council member to Facebook Live, and then it posted that photo on Facebook for everybody to see. And I mean, no disrespect to the council member. That council member would not have been live streaming that if they were told not to do so. This is not someone who would do that. So I mean, no disrespect to the council member. I don't think that council member never would have done that had they not been told. But again, it just goes to this argument about the CSI Act. And again, you can kind of hear the frustration in my voice on this. Because again, you can see this as it was fascinating that the CSI Act didn't come up until we were requiring and the court was ordering that these documents be turned over. So there are safeguards to protect the essential records. These documents are protected in the RFP process. The city and any participant in the RFP process are required to sign a non-disclosure agreement and have to comply with all CSI laws. And given that the potential bidders must be experienced utilities, they are already familiar and compliant with these CSI laws. So I said earlier, the Chester Water Authority was holding back these documents, right? And so what ended up happening is the city filed a motion to get these documents. And lo and behold, what happened literally the day of the morning of the hearing, which was at noon, we learn that CWA turned over more than 12,000 documents that are now being examined by the receiver's legal team. So again, up until this point, nothing, right? Said they were going to comply with the court's order, didn't, filed a bunch of different motions over there, claimed all of these reasons of why they couldn't give it. But literally the day that they had to answer to the bankruptcy judge, they dropped 12,000 documents on us, right? And all that time was wasted, right? Weeks, months were wasted here. And this is gamesmanship is exactly what this is. I think we're being polite here when we're saying compliance or convolution. There's only one conclusion to this. Like you don't hold out and file a bunch of motions, and then drop 12,000 documents the morning of a hearing, unless you're stalling. And that's what they've done at every step of this process. And the problem with that, not only are we losing time, and we're going to talk about in a moment why I've had to push out the RFP response date, but this is also costing money, and it's costing money for lawyers, and it's costing money for ratepayers. And so they're huge legal bills that are being churned here. And I use the term churn, and lawyers know what that means. That ultimately the public is going to pay. But here's the difference, right? Like we have now publicly filed a copy of our invoices that show how much legal time we have had to spend, our lawyers have had to spend, simply to get the documents that the bankruptcy court previously ordered CWA to deliver. So over a 3-month period, right, in responding to all of the motions, right, which CWA lost, each one of them, right, and has decided to continue to appeal, our attorneys had to spend fees exceeding $130,000 on this. That's what we've had to spend, right, in taxpayer dollars. What's interesting, though, is we don't know what CWA has been spending. They've got a cadre, an army of lawyers themselves, and we don't know how much they've been spending. They fly in an attorney from Michigan to argue these cases in front of the bankruptcy court. And again, they've got a fair number of lawyers on their side. And again, this is ratepayer dollars being used to really stifle what's a legitimate process that the receiver is trying to undertake, right? And one where there is, where there are protections and where we have already indicated that a requirement is that the assets need to remain in public hands. And so there's more, right? There's actually more when it comes to this. One is excuse me one second over here. I'm going to make sure I have this. So so on Monday, August 11th, so literally yesterday, Save CWA sent out an email saying that CWA was, quote, thrilled to announce that it has retained Consovoy McCarthy in Arlington, Virginia, as appellate co-counsel for certain appeals that, quote, turn on significant federal constitutional issues. So if you go to their website, and if you read the email that Save CWA put out, these attorneys have argued 12 cases before the U.S. Supreme Court and dozens more of the Court of Appeals. So if you look on there, these are lawyers who clerked for Supreme Court justices and who handle appellate matters. And I can tell you, as an attorney, unless these folks are doing this pro bono, constitutional firms in DC do not come cheap. And so, what was interesting was in that e-blast, they didn't mention how much the rates were or how much this was going to cost. But who's paying for this other group of attorneys? It's the ratepayers. And so what is this all about in terms of this matter? This actually has to do with something that happened earlier where CWA's solicitor, as well as another third-party law firm that they hired apparently to file right-to-know requests, sent letters to potential bidders suggesting that the RFP process that we were about to undertake was a sham. And we argue that that action violated a stay order that is very standard in bankruptcy, right? We don't have an issue with being criticized. I certainly don't do that. But when you're essentially not telling the truth and calling a process a, quote, sham, and essentially sending what any person would take as a threat, we're going to take action. And the bankruptcy court agreed. It wasn't just us. The bankruptcy court agreed and ordered CWA to comply with the bankruptcy code and to stop making comments that harm the value of the city's water assets and the RFP process. It wasn't a gag order. It wasn't preventing CWA from telling the truth about the situation, right? It was preventing CWA from issuing essentially threats and lying about the situation, right? And again, this is something that the bankruptcy judge did. And again, this is these are the, this is why CWA apparently is hiring appellate lawyers from DC. So how CWA reacted? In recent weeks, CWA has claimed that its First Amendment rights were being violated. The First Amendment applies to people. It does not apply to governments. CWA apparently is looking to create some new law in this area. We saw a recent headline in the Delaware Valley Journal that said, "Court muzzles CWA while city courts bidders for the water system." And in that story, Frank Catania, the general counsel for CWA, same guy who sent the threats to the entities, said, quote, "I'm not allowed to talk about the receiver at all." So again, I have my own thoughts on this, but let's actually look at what the bankruptcy judge said. So there was a hearing on August 6th, and there was a transcript of this hearing that anyone can read. And Judge Chan said that CWA at this hearing said that CWA can talk about the bankruptcy case and the possible monetization of the water assets. CWA just had to tell the truth, setting a pretty low bar here, right? And this is a quote from the judge, quote, "I think the language on the discovery that was sent out, quote, like, why are you involved in this bidding process? It is a sham. From my perspective," again, this is the judge, "that was really over the line and unfortunately has caused this cascade of litigation." Again, from the judge, quote, "I don't want to limit your First Amendment rights. You can say the truth." And finally, quote, "Stick to the facts, what your legal arguments are. Things like that will not get you into hot water," right? So this is kind of the matter, right? This is the issue. It is those right to know requests that CWA has decided are so important that they've decided to hire, again, what is likely to be a very high-priced appellate practice out of Arlington, Virginia, in order to argue this case on appeal, right? And to me, like, that is just incredibly wasteful That's just that is just an incredible waste of ratepayer dollars. Um, uh, so in terms of the next steps, right? Let's talk about kind of what's going to go on over here, and then I'll let anyone who's got any questions or comments here from the committee note as well. The RFP process is going to continue, but I've had to delay the response date 60 days to November 3rd, 2025, due to delays caused by CWA. Again, due to all these delays in the litigation. The next step, I will also continue the policy of requiring water assets to remain publicly owned. And I will continue to ensure that the city's and its residents' rights are protected in the bankruptcy process. As always, if folks have questions or comments from the public, please email us at info@chesterreceivership.com. Our website, chesterreceivership.com, also has a lot of the filings on there. There's the Donlin Ricano docket. That's also, you can see a lot of these filings there as well that I'm happy to show, and you're happy to read for yourself. But again, I would encourage members of the public, members of the press who might be interested, take a look at that August 6th transcript. Take a look at that hearing and to get a better sense of, again, why this process is taking so long, unnecessary reasons for why we're having to spend legal dollars to do this, in order just to get information that the city is legally entitled to and that a court has already ordered is entitled to. So with that, let me pause. Let me offer the opportunity for the committee to ask any questions or make any comments. Yes, Mayor.
Couple things. Is there a hybrid solution to ownership, specifically kind of private company operate the asset being the water utility while ownership remains in public hands?
So yes, that is one potential option that we would certainly consider, because again, it would remain publicly owned.
Okay. In that RFP kind of bullet list you had there, one of the bullets were improve access to capital. That's something you're looking for. I don't know, being in Chester, I often wonder, is economic development being stifled by Chester Water Authority because they can't seem to raise enough capital to do the type of capital improvements we need throughout the city, with namely new water mains on certain streets that are so old that if we were to develop on those corridors, we can't even plug in to the water mains. What's the solution there? Is there a limit to what our public, and I guess a complementary question to that is, like, I'm a Chester Water Authority customer. I've noticed my rates have gone up the last couple of years. Not insignificant, but not absorbent, not crazy either. I don't believe it's because of infrastructure improvements, but as I keep hearing about all this money being spent on attorneys, is there any correlation there that you could see?
Yeah, so a couple of answers to that, Mayor. I mean, one is, so I don't know how, and I don't think anyone knows how much has actually been spent by Chester Water Authority on their lawyers, right? Whether that's their third-party lawyers who are arguing this, the new lawyers, their solicitor, whatever. I mean, you can see from the receiver's end, right? Because our contracts are effectively public, right? And you can see how much that is, but we don't know how much that is. Like there was a quote in the Daily Times when that question was asked of the solicitor, and his response was, "We've saved $500 million," and there was no follow up to that. It was just sort of taken. So there's the first question of like how much is actually being spent on that, which I think is important to know, right? Ratepayers want to know. You want to know, is that taking away from capital projects? I'm sure the union, the SEI union, who is about to start negotiations, will probably want to know too, kind of, regarding that. And ratepayers want to know as well, right? To the extent of all that is doing that. All that is sort of being factored into the rates. In terms of the overall capital, Mayor, what we're hoping to do with this is again, to the extent there a third party could come in when they monetize the asset, is perhaps have greater access to capital. Maybe they do, right? And that's something that we're hopeful to do because, like you said, it is important to get these infrastructure projects done in Chester. It's important. I think I know from your concerns too about the potential for lead pipes that are still in Chester, right? To make sure that all that infrastructure is is being improved, right? Because at the end of the day, monetization or not, the Chester Water Authority is still providing service to Chester residents, right? And people don't really realize this, but like there are very old water mains in Chester, some dating back to early 1900s. And so you can't just put up, say, people talk about economic development, you can't just put up like a new apartment complex, right? Because it's got to tie into, it's got to, that the water system and the infrastructure has got to tie into the water needs of that type of entity. So or that type of building. So there is a lot I think there's a lot here that is kind of being discussed. Obviously, a lot of the discussion here has been on the monetization, but as part of this, it would also be great if we could see services improved too, whether that's capital or otherwise. Did I get all of them there? Did I hit all those?
Yes. Okay. Very good. Thank you.
Sure. Other questions or comments?
Yeah, Mr. Receiver. The situation where it may stay in public, an asset may stay in public hands, but it's managed by some kind of private firm. Is that the same? Would that be the same thing as a long-term lease? Or is there a differentiation there in that scenario?
Yeah, possibly, Andrew. Again, like this is something that I think, we're eager to get potential ideas, back to consider, but that is something we would consider. But the idea again is that we would want to remain, it would need to remain in public hands. It would have to depend, Andrew, too, on like how that lease is structured, right? We don't want to be in a situation where we're essentially where the asset has been quote unquote essentially been privatized, but it's called something else, right? I mean, we are in good faith, have concerns about rates, have concerns about the common good, as I talked about before. Those are important, right? And people here in the community know this. I mean, Mayor knows this, Kelly knows this. With the hospital system, and these aren't necessarily the same thing, but we see sometimes what happens when the incentives of a private entity override the public good, and that's not something we want to do here.
Just one more question. Can you help me understand, or the group understand, if monetization goes through and consummates, what exactly happens to that money? You have creditors, you have to deliver a standard level of services to the city, you're in bankruptcy. Like, how are decisions made? What happens with that lump sum of cash?
Right. So great question. And before I answer, let me jump back really quick to the mayor who asked about the rates. So I do want to make clear, like, rates are increasing across the board, right? The mayor was talking about how there were increased rates in CWA. Those are happening kind of across the board. The question of why is the main question, right? Which is where you got to it. So it's not unusual. And again, we're seeing it too, like in construction and across the board. So this doesn't mean, whether it's monetization or otherwise, this doesn't mean that rates are going to remain stable forever, right? That's just the economics doesn't work that way. The pressure is eventually going to go up. And that's when we talked a little bit about before, where you may be in a situation where folks argue, well, I'll keep the rates low for 10 years or keep them stable for 10 years. But again, what you see at the end of the 10th year is this, right? I mean, that's just basically artificially suppressing the rates. And so, I do want to make clear for the public that that rates are going to go up. At the same time, though, what we really want to make clear is why they're going up, right? If they're going up for capital reasons and inflationary reasons, that's one thing. If they're going up to pay legal fees for an Arlington, Virginia appellate attorney who clerked for, Justice Roberts, I'll leave that up to the board and to other ratepayers to, to determine whether or not they think that's in their best interest. And again, in order to defend the quote First Amendment to issue threats against potential bidders to an RFP process. But Andrew, to your question about like where would the money go? So again, all of this is part of what will get rolled into what's called the plan of adjustment, right? The plan of adjustment at the end of this process, what our goal is to submit to the bankruptcy court in order to get out of bankruptcy what a plan is, a plan of adjustment. And that's kind of like a recovery plan. At the end of the day, that is the path by which you're gonna show how revenues are spent, where money is going to be spent, and show to the bankruptcy court that you've addressed to the extent you can the issues of the creditors, but you also have a sustainable path going forward. And so, Andrew, in terms of kind of what that would look like, right? Assuming a monetization does occur, right? All of that is going to be part of the plan of adjustment, and that we will obviously try and work with creditors in order to determine kind of what's in the best interest of the city and what's also in the best interest of the creditors. That's going to be ultimately part of the negotiations, which again have been stalled outside of the monetization context because understandably most of the parties don't want to engage in these types of talks and offer concessions if they don't know how much revenue may be out there. So again, we're stuck in this dance so that not only is this costing us money with these litigation tactics, but it's also it's not only delaying the monetization process, but it's also delaying everything else in this part of the bankruptcy, right? So we've just lost 60 days, right? Plus, right, going from September to November here because of this, right? And that's on top of all the money that was spent. So does that answer your question, Andrew?
Yeah, it does. Thank you.
Thank you. Thanks. Any other questions or comments from the committee? Yeah, Kelly.
I have a question, sort of piggybacking off what Andrew asked. Are there any other models in Pennsylvania for water assets specifically where the operator is private, but the assets remain publicly owned?
Yeah, I think there's a couple there's none that are coming directly to mind. I think there's a couple in the western part of the state where that is. And again, we're open, right? We're open to interesting ideas here. Like again, we're, to be creative and otherwise. And again, there's none are coming to the tip of my tongue, and I apologize for that. I can certainly work on that, in the next couple of weeks to get to the committee. But this is not something that would be so different that like there wouldn't be some type of models out there before.
And my other question was, is there any sense of when, or I guess when the Supreme Court would hear the appeal? I don't know if there's any sense on like timing for that. And also, I guess to that theoretically when that is scheduled and heard and decided, would that put this issue to bed?
Yeah, it's a good question. So Kelly, on the Pennsylvania Supreme Court, so they have heard oral argument. The question right now is like when the decision comes down, right? And then hopefully the decision will be clear enough that like we'll know what the path forward is, right? Sometimes courts will again understand like it is their prerogative to do that. This is their job, not mine. I don't interpret the law, but hopefully it'll be a clear enough decision that we'll know what path forward it is. It's really hard to tell until you actually see the decision. Right. It could go in multiple different ways, right? It could go 100% for the city, it could go 100% for CWA, could split the baby, right? There's a lot of, the Supreme Court has a lot of leeway. Pennsylvania Supreme Court has a lot of leeway in that. If past is any like, if the past patterns continue, like, I mean, given the litigation that we're seeing right now in the federal court, about this information. Again, I want to be clear. I know it sounds like I'm piling on here, but as an attorney, like, you can just kind of see, clearly I have my own take, right? But there's appeals and then there's appeals, right? And what has been done over here, and let me give you an example, right? So what will happen is you'll get we'll file something to say we need this information. The court will find in our favor, right? Judge Shan will find in our favor. The next thing that CWA will do is they'll file a motion for reconsideration, right? That's not an appeal. That's literally asking the judge, hey, judge, I know you just ruled against me, but could you reconsider it, right? Like, it's kind of like, are you sure, judge? Right? It's like an are you sure, judge? And like, if you were at the oral argument, it's pretty clear that the judge was like, yeah, I'm pretty sure what I'm doing here, right? But that extends it, right? Because then they can file that within 2 weeks, and then we have to respond within 2 weeks, right? So boom, you've got 28 days right there, right? That you've just kicked this out, right? Plus a bunch of things that have to get filed. And the other thing that CWA will do is there's usually page limits here in terms of like what you're allowed to file. In something that's required of a 5-page page limit, they'll file 80 pages, and that's not exaggerating, right? So then we've got to respond to all that, right? Regardless of how, of how meritless the argument may be. So, I mean, I really want to, again, I realize like we're in litigation right now, but I really want like not only the committee to understand this because it is costing dollars, but also members of the public to understand this, and also elected officials, right? So the Chester County Commissioners, the Delaware County Council, the Chester City, City Council. You were the ones who were appointing members to the board of CWA, as it currently stands, right? And to the board members of CWA, like, is this the best use of dollars? And again, I think it's important for the CWA. Again, don't tell us, don't reveal attorney-client privilege information, but it would really be helpful to know so the public understands like how much this is really costing, right? Because there isn't some just kind of like, open tab here that you can just keep spending money. And again, to go and hire, an appellate firm out of DC where you've got members who are, arguing cases in front of the U.S. Supreme Court and have clerked for justices, over the issue that you're litigating, it's not even relevant to the ultimate monetization and to the ultimate ownership. So again, I know it seems like I'm sort of piling on here, but I really do want the committee to understand this. And by all means, for members of the press who may be watching this, fact check me. Go look at all the filings. Go look at everything that has been filed here before. We're telling the truth here. We absolutely are. And it's wasting ratepayer dollars, and it's wasting taxpayer dollars, and it's wasting time that Chester doesn't have.
Mr. Receiver, you didn't answer one of her questions, though. She
was
said,
that?
give us a guess. How long is it going to take before the Supreme Court rules?
My guess, the Pennsylvania Supreme, I think we're not going to see it until January or February of next year. That's what I think. That's my own guess. That's my personal guess.
Thank you.
But I have no insight, right? So I don't know. It's me sort of prognosticating. So, other matters here took years, right? In some of the other matters that we had. But where I'm sitting, I'm not expecting this to be heard. Excuse me, I'm not expecting a decision until early next year at the earliest. Any other questions?
Well, since we're talking about lawyer fees quite a bit, like that one that's costing the city quite a bit of money, the ones representing the retirement community, is there a way to, once I guess Supreme Court rules, to get that piece decided and them off of our checkbook?
So that will be part of that again, Mayor, is going to be sort of part of the plan of adjustment. This is one of the things that as part of getting out of bankruptcy, the issues with the attorney's fees kind of across the board, right, have to be resolved. So, we could, that one is, again, this is part of the bankruptcy process, right? I mean, the retiree committee, has a right to exist, right? I mean, that's part of it. And we knew going in that their fees and their professionals would be covered. It was up to the retirees to choose who they wanted, right? And they did. Those fees are significantly higher than the fees that our counterparts in the city, that the state is paying for, just so folks know. but that's going to be resolved, I think, at the end. Now, we do have the ability to object to fees that we believe are not proper, and we do have a standing objection out there. I don't want to get into specifics about which ones and whatever, but that is something that we are we are paying attention to. Any other questions? All right. Well, seeing none, thank you all for sitting through that. That'll probably be one of the longer ones that we have. We'll be happy to, again, keep folks updated on this. Our next MFRAC will be on August 26th, back here at 1 o'clock. So we appreciate everyone's attention, appreciate everyone's time. Thank you all for the great questions and discussion. And with that, this meeting is concluded. Thanks, everybody. Take care.